What happens if one party refuses to sign the stipulation of settlement agreement in New York? Are there any legal remedies or consequences?
No. Both parties have to agree on a settlement. So if one party refuses to sign off on a settlement, that means the case isn't settled. Um, Now, one should determine what the disagreements are, and come up with middle grounds that hopefully both parties will agree to, perhaps with the aid of a mediator, perhaps with the aid of the court, because sometimes if parties agree on 98% of the terms, but they have a few disagreements, uh, I've gone to the judge on several of my contested cases and sought a quote unquote advisory opinion. As long as both parties and both counsel are in agreement with soliciting the judge's advisory opinion, the judge is more than free to step in and say, well, of course, I can't prejudge what I'll do at trial, but based on what you're telling me, this is how I would recommend you resolve the impasse. Sometimes the judges feel a little uncomfortable with that, so they'll delegate that task to their court attorney, and that's totally fine as well. But the bottom line is if party doesn't execute the agreement, you have to either agree on other terms, or you have to inform the judge that unfortunately the case isn't settling, so we're going to have to take the case to trial.